Our next speaker is Professor Nicholas Aroney, who was educated at the University of New South Wales and the University of Queensland before obtaining his PhD at Monash University. He is Professor of Constitutional Law at the University of Queensland's T.C. Burns School of Law and an external fellow at the Centre for Law and Religion at Emory University. He's held visiting positions at the University of Oxford, University of Cambridge, Paris II, Edinburgh, Durham, Sydney, Emory and Tilburg universities. He's published over 150 journal articles, book chapters and books in the fields of constitutional law, comparative constitutional law and legal theory. One of his most recent book chapters is High Courts in Federations, Neutral Referees or Team Players. He's a frequent speaker on the international conference circuit on topics such as federalism and law and religion. He's the current co-convener of the Queensland chapter of the Australian Association of Constitutional Law, and he's also the grandfather to 2 children. Please join me in welcoming Professor Nicholas Aroney.
Thank you, Robin, for mentioning what is my proudest achievement, my 2 grandchildren. It's now totally put me off. I can't even stop to think that. It's a real honour to be here. Thank you, Robin, for your kind words. Thank you, Xavier, for the invitation and the committee members. It's a real pleasure to be here. My approach will be a lot similar to Scott's in the sense of just talking about the technicalities rather than the pro or contra case. It seems to me that questions around the meaning and effect of the constitutional proposal can be organised into essentially 6 topics or 6 questions. Firstly, there's the question around the structural implications of the establishment of an Indigenous voice in its own chapter of the Constitution, thus giving the institution a constitutional status equivalent to, or comparable to, I think is probably the better term, the Parliament, the Executive and the courts. Secondly, there's the legal consequences of the constitutional recognition of Australia's Indigenous peoples as the first peoples of Australia. Thirdly, there's the constitutionally prescribed nature and composition of the voice as a body in the singular, that is, we would understand to be Indigenous. And what does that mean? Fourthly, there's the constitutional implications, if any, that will be attached to the right to make representations to the Parliament and the executive government, something that Scott touched on in question time. Fifthly, there's the question of what particular institutions, agencies and office holders are comprehended within the term executive government, again a thing that Scott touched on. And finally, within these parameters, to what extent will the Parliament be able to legislate with respect to matters relating to the voice? That's a very important question as well. Much of the debate, I think, is centred on this latter question, the extent to which the Parliament will have power to determine not just the composition, functions and powers and procedures of the voice, but other matters relating to the voice. Noting that the Parliament's power will be subject to the Constitution and therefore of the mandatory requirements of clauses 1 and 2 in the proposal. In the submission Peter Gerangelos and I made to the Parliamentary Committee, we attempted to identify and address several of the constitutional questions we believe arise. On some issues we did not express a concluded view, principally because we could not see a clear or decisive answer. On others we did express a view while acknowledging that it is difficult for any of us to be absolutely certain about the precise meaning or effect of a constitutional amendment of this kind. I'll take the same approach to my paper this morning. It will build on some of the observations we made in our submission to the Parliamentary Committee with a particular focus on a question that has not received, I don't think, very much consideration in the debate so far. That question concerns the legal consequences of the constitutional recognition of Australia's Indigenous peoples as, and I quote, the first peoples of Australia. Now, the proposed Section 129 begins with a set of introductory words in the following terms, and again I'll quote, in recognition of Aboriginal and Torres Strait Islander peoples as the first peoples of Australia. Notably, these introductory words are separate from the 3 operative clauses that establish the body, affirm its right to make representations, and empower the Parliament to make laws with respect to it. At the outset, it could be argued that the legal effect of the recognition of Australia's Indigenous peoples is limited to what is required by the three operative clauses. In other words, it has no implications beyond the legal effect of those clauses, interpreted in the light of the introductory words. However, it could also be argued that the introductory words contain implications of their own. The three substantive clauses might spell out three particular constitutional imperatives premised on the recognition of First Peoples, but the recognition of Australia's First Peoples is itself a central objective of the new section, which has implications of its own. To consider why this might be the case, it's instructive to compare the current amendment proposal to the new preamble put to the Australian people in the constitutional referendum of 1999. The proposed preamble then similarly recognised, and I quote, Aborigines and Torres Strait Islanders as the nation's first people. Different terms, note. However, this was to be accompanied by an additional section which provided that the preamble was of no legal force and was not to be considered in the interpretation of the Constitution. Notably, the Constitution Acts of four of our states at least, New South Wales, Victoria, South Australia and Queensland, which also recognise Indigenous peoples in one term or another, include similar limiting clauses. In the absence of a limiting clause of this kind, the opening words of the new section 129 are likely, at a minimum, to inform the interpretation of the section itself and its place or operation within the Constitution as a whole. However, beyond that, it seems to me that the constitutional recognition of Australia's First Peoples has every prospect of carrying additional implications of its own. What might those implications be? Several questions arise. The first and most basic question is this: how will the recognition of Indigenous peoples be conceptualised constitutionally? And in particular, how will it relate to the constitutional conception of the Australian people? In Canada and the United States, the terms more frequently used in the case law are First Nations and domestic dependent nations. While the word nation may carry a relatively stronger signification than the term people, the words can be used interchangeably. The Macquarie Dictionary defines nation as, and I quote, a relatively large body of people living in a particular territory and organised under a single, usually independent, government, while it defines people as the whole body of persons constituting a community, tribe, race or nation. Unlike the proposed section 129, the Uluru Statement from the Heart uses the terms First Sovereign Nations and First Nations, not First Peoples. The International Covenant on Civil and Political Rights protects the right to self-determination of, and I quote, all peoples, while the United Nations Declaration on the Rights of Indigenous Peoples affirms the right to self-determination of all Indigenous peoples. The reference to the First Peoples of Australia in the proposed section 129 is likely to be interpreted in the context of the reference in the existing preamble to the Australian Constitution to the agreement of the people of the several Australian colonies to unite in an indissoluble federal commonwealth under the Crown and under the Constitution. Several justices of the High Court of Australia have affirmed that, since the termination of the authority of the British Parliament to legislate for Australia in 1986, ultimate sovereignty is now vested in the Australian people. The opening words of section 129 would, if enacted and amended, would raise similarly fundamental questions about the constitutional status of and relationship between the First Peoples and the Australian people. Now, the Australian Constitution presently recognises the distinct existence of the people of each state, but also treats them as integral parts of the people of the Commonwealth. And both the people of the states and the people of the Commonwealth are conceived as self-governing peoples. In similar terms, it is quite possible and indeed likely that that the term the First Peoples in the proposed section 129 will be recognised as a distinct and yet integral part of the Australian people. What I mean is that the Indigenous peoples will be seen as distinct as regards their status as First Peoples, but integral as regards their equal status as Australian citizens. And this is what Peter Gerangelos and I said in our submission. But this is where I want to go deeper, because I think there are further complications. The first complication concerns the implications of the High Court's recent decision in Love and the Commonwealth. Why does that keep being mentioned today? In that case, it was held by a majority that Aboriginal Australians are not within the reach of the Parliament's power to legislate with respect to aliens. One premise of that conclusion was that Aboriginality would be determined according to the tripartite test referred to or articulated by Justice Brennan in the Mabo decision. The third element of that test requires recognition by the elders or other persons enjoying traditional authority among the people concerned. The three dissenting judges in Love and the Commonwealth, Chief Justice Kiefel and Justices Gageler and Keane, considered explicitly that this implied the recognition of a measure of Indigenous sovereignty, insofar as it empowered the traditional holders of authority to determine a person's status in a manner that limited the power of the Commonwealth to determine conditions of citizenship and entry into the country. As the Chief Justice put it, and I quote, "To suggest that traditional laws may be determinative of the legal status of a person in relation to the Australian polity is to attribute sovereignty to Aboriginal groups." Now, this appeared to contradict a long line of cases that had decided that sovereignty is vested exclusively in the Commonwealth and that all persons within Australian territory are subject to the duly enacted laws of the Commonwealth, the state and territory parliaments. The majority justices, Justices Bell, Nettle, Gordon and Edelman, did not consider this to be an implication. Justice Gordon, for example, affirmed that Australia's Indigenous peoples are an integral part of the Australian people, and it's in the Australian people that ultimate political sovereignty is reposed, and that this would be directly contradicted by any notion of Indigenous sovereignty. Juxtaposed against that reasoning, which, remember, was articulated in the absence of the proposed Section 129, what would the constitutional recognition of Aboriginal and Torres Strait Islanders as the First Peoples of Australia imply? Here it is worth observing that in Co and the Commonwealth No. 2, the plaintiffs sought declarations that a particular Indigenous group were a sovereign nation of people, or a domestic dependent nation entitled to self-government, or, and I quote again, a free and independent people. In that case, Chief Justice Mason held that all three claims amounted to a claim to sovereignty, even when the word sovereignty was not expressly used. I noted earlier that the term domestic dependent nations is generally used in the United States. The term designates those Indian tribes that are considered to possess a qualified form of sovereignty which continues to exist subject to the sovereign power of the US Congress. As Justice Stewart put it in United States and Wheeler, the sovereignty that the Indian tribes retain is of a unique and limited character. It exists only at the sufferance of Congress and is subject to complete defeasance. But until Congress acts, the tribes retain their existing sovereign powers. In sum, Indian tribes still possess those aspects of sovereignty not withdrawn by treaty or statute, or by implication as a necessary result of their dependent status. It followed for Justice Stewart that subject to these qualifications, the Indian tribes continued to have jurisdiction over their own internal affairs, including the power to prescribe and enforce criminal laws against their own tribal members. Consistently with the approach generally taken in Australia, the High Court has rejected the proposition that Australia's Indigenous peoples have the status of domestic dependent nations in the sense used in the United States. However, the question arises whether constitutional recognition of Australia's First Peoples might change this. In this connection, it is noteworthy that in Love and the Commonwealth, one of the reasons Justice Gageler gave for his dissenting judgment was his reticence as a judge to engage in what he called the judicial creation of a race-based constitutional limitation on legislative power, no matter how benign that limitation might be. Creativity of that nature and to that degree, he said, is not within the scope of the acknowledged judicial function. Noting, however, and I quote, the national conversation presently occurring about amending the Constitution to include an Indigenous voice, His Honour went on to say that if the scope of the power of the Parliament is to be changed in the way proposed, then the Constitution should be amended to produce that result by referendum, as had occurred in 1967 in relation to the race power. So clearly, a constitutional amendment is a change to the fundamental ground rules of the legal system as a whole. The recognition of Australia's First Peoples in the Constitution is a change to the system at the most fundamental level, because it is the recognition of peoples who possess the continent prior to the people of Australia, to whom ultimate sovereignty is now ascribed. It is thus of the utmost significance precisely how Australia's First Peoples will be conceptualised as a result of the insertion of the proposed Section 129 and how they will relate to the Australian people as a whole. Now, a further complication arises out of the reasoning of Chief Justice Gleeson and Justices Gummow and Hayne in the Yorta Yorta case. In that case, the plurality began their reasoning with the premise, consistently with earlier decisions, that the Crown's acquisition of sovereignty cannot be challenged in Australian municipal courts. This entailed the corollary, they reasoned, that there could thereafter be no parallel lawmaking system in the territory over which such sovereignty had been asserted. The rights of Indigenous peoples must depend, therefore, on their recognition by the new normative system introduced at British settlement. This new normative system, the plurality affirmed, recognised that the then existing rights and interests of Australia's Indigenous peoples, these being rights and interests derived from the traditional laws and customs of those peoples. However, because no parallel lawmaking system persisted after the assertion of British sovereignty, the traditional body of Indigenous laws and customs did not have the capacity, they concluded, to generate new rights and interests. The plurality went on to state that rights and interests under a body of law and custom are always the product of a particular society, which they defined as a body of persons united in its acknowledgement and observance of such laws and customs. The reasoning is a little bit circular here. Accordingly, they continued, if a traditional society should cease to exist as a group, those laws and customs and the particular rights and interests arising under them would also cease to exist. However, they observed, if the content of those laws and customs should later be adopted by the new society, those rights and interests might be given, and I quote, new life. This gives rise to a question. Might Section 129, in recognising Australia's First Peoples, have the effect of giving new life to the Indigenous societies to which the Yorta Yorta plurality referred? Could it be interpreted to affect a kind of resurrection of those societies in legal terms, including their traditional laws and customs, particularly in those cases in which the courts have found that the continuous observance and acknowledgement of those laws and customs could not be established? If so, how far could this reasoning be taken? Could it resurrect narrowly particular rights and interests, or more broadly, particular laws and customs, or more broadly still, particular social and communal identities, and even some degree of sovereignty or autonomy or lawmaking power vested in Australia's First Peoples? As Justice Kirby observed in the Wick case, different considerations arise in different societies where Indigenous peoples have been recognised, in effect, as nations with inherent powers of a limited sovereignty that have never been extinguished. Might the recognition of Australia's First Peoples in the proposed Section 129 have this sort of effect? It's difficult to be sure, but the possibility needs to be considered. A further question concerns the possible application in Australia of the doctrine developed in both Canada and New Zealand of the honour of the Crown, and the consequential duty of the Crown to Indigenous peoples, an obligation which has been characterised as a kind of fiduciary duty. Would constitutional recognition provide a basis for the development of these or similar doctrines in relation to Australia's First Peoples? The early Canadian cases, as I understand them, found that the Crown owed a special fiduciary duty to Aboriginal peoples in respect of native title rights over land surrendered to the Crown under statute. Later cases appear to have reconceptualised the fiduciary duty as being grounded in the doctrine of the honour of the Crown. According to a recent statement of the position in Canada, the principle of the honour of the Crown derives from the Crown's assertion of sovereignty in the face of prior Aboriginal occupation. Would constitutional recognition of Australia's First Peoples as the first occupiers of Australia have a similar effect because it would affirm that occupation prior to the assertion of British sovereignty? Now, the status and rights of Canada's Aboriginal peoples are expressly recognised and protected by the Canadian Constitution. Section 35 of the Constitution Act of 1982 states that, and I quote, "The existing Aboriginal and treaty rights of the Aboriginal peoples of Canada are hereby recognised and affirmed." The Supreme Court of Canada has held that Section 35 incorporates the government's responsibility to act in a fiduciary capacity with respect to Aboriginal peoples in a manner that imports certain limitations or restraints on the exercise of sovereign power. Reflecting on the wider significance of Section 35, Chief Justice Dixon and Justice LaForest quoted with apparent approval the statement of one scholar that, and I quote again, "The context of the constitutional amendments of 1982 in Canada is surely enough to tell us that this is not just a codification of the case law on Aboriginal rights that had accumulated by 1982. Section 35 calls for a just settlement for Aboriginal peoples. It renounces the old rules of the game under which the Crown established courts of law and denied those courts the authority to question sovereign claims made by the Crown. Their honours concluded that Section 35 should therefore be interpreted in a generous, liberal and purposive manner. The Canadian Supreme Court has also held that it is a corollary of Section 35 that the Crown act honourably in defining the rights it guarantees and in reconciling them with other rights and interests. As Chief Justice McLaughlin explained, and again I quote, "Canada's Aboriginal peoples were here when Europeans came and were never conquered. Many bands reconciled their claims with the sovereignty of the Crown through negotiated treaties. Others, notably in British Columbia, have yet to do so. The potential rights embedded in these claims are protected by Section 35. The honour of the Crown requires that these rights be determined, recognised and respected. This in turn requires the Crown, acting honourably, to participate in processes of negotiation. While this process continues, the honour of the Crown may require it to consult and, where indicated, accommodate Aboriginal interests." These Canadian cases have often involved claims over land or rights pertinent to such claims. However, they've also involved claims to Aboriginal rights that exist independently of native title, and there have been suggestions that the Crown has a broader responsibility to act as a fiduciary with respect to Aboriginal peoples generally. I certainly don't profess any deep understanding of the intricacies of the Canadian jurisprudence, but it does seem clear that the amendment of the Canadian Constitution in 1982 has had significant ramifications. The Australian constitutional context is different from Canada's, and one would not expect any simple one-for-one correspondence between the legal doctrines developed in the two countries. However, their constitutional histories also have several important similarities, and where these exist, the jurisprudence of the two countries is often run along parallel lines. To date, Australian courts have not affirmed the doctrine of the honour of the Crown or the proposition that Australian governments owe fiduciary duties towards Australia's Indigenous peoples. However, the point has been argued in cases and there's been discussion of it in several High Court and Federal Court decisions. In fact, in the Mabo case, Justice Toohey affirmed the existence of a fiduciary duty. He said that while native title could be extinguished, such extinguishment would involve a breach of the Crown's fiduciary obligation to the title holders, for which it would be liable to pay compensation. The basis of His Honour's conclusion was that the power of the Crown to alienate land, the subject of native title, existed and would thus impair the traditional Indigenous rights and interests in land, and that this would give rise to a fiduciary obligation on the part of the Crown. His Honour considered that to the extent the Crown is a fiduciary, it must act for the benefit of the beneficiaries, and that this entailed an obligation to ensure that traditional title is not impaired or destroyed without the consent of the title holders. His Honour went on to say that such a fiduciary obligation does not limit the legislative power of the Parliament to extinguish native title, but such legislation would be a breach of the fiduciary obligation if its effect were adverse to the interests of the title holders, or if the process it establishes does not take account of those interests. None of the other judges followed Justice Toohey in this line of reasoning. However, Justice Brennan did consider that there could be specific circumstances where a fiduciary duty might arise. In his dissenting judgment in the Wick case, Chief Justice Brennan made similar comments, as did Chief Justice Mason in Coe and the Commonwealth about the fiduciary duty. Summing up the state of the law in Thorpe and the Commonwealth some years later, Justice Kirby observed, and I quote, "Whether a fiduciary duty is owed by the Crown to the Indigenous peoples of Australia remains an open question. This court has simply not determined it. Certainly, it has not determined it adversely to the proposition. On the other hand, there is no holding endorsing such a fiduciary duty." In Bodney and Westralian Airports Corporation, Justice Lehane made similar observations. Indeed, he went so far as to say that there was nothing surprising in the conclusion of the Canadian Supreme Court, that the disposal by the Crown of Aboriginal lands under a statutory scheme should give rise to a fiduciary duty to act in the interests of the members of the band. However, His Honour also noted two important distinctions between the Canadian and Australian contexts. Firstly, he noted that there had been a constitutionalisation of Aboriginal rights in Canada by Section 35 of the Canadian Constitution. Secondly, he noted that the law relating to fiduciary duties had developed differently in the two countries. In relation to constitutionalisation, Justice Lehane drew attention to the statement of Chief Justice Dixon and Justice LaForest in one case, that the recognition and affirmation of Aboriginal rights in Section 35 not only incorporates the fiduciary relationship between the Crown and Aboriginal peoples, but also imports restraints on the exercise of sovereign power. Justice Lehane then drew attention to the statement of Chief Justice Lamer in another case, to the effect that legislative or governmental measures affecting Aboriginal peoples must be justified so as to comply with Section 35. In all such cases, he said, consultation in good faith is required with the intention of substantially addressing the concerns of the Aboriginal peoples whose lands are at issue. Most cases will require something, and I quote, significantly deeper than mere consultation, and some might require full consent of an Aboriginal nation. As one Canadian scholar put it, the Crown has a duty to consult Aboriginal communities prior to undertaking or authorising activity that could adversely impact Aboriginal or treaty rights. And, if the need for accommodation is revealed through consultation, has a companion duty to accommodate the applicable concerns of the community. Notably, It has also been argued in some of the Canadian cases that Section 35 protects a right to self-government of Aboriginal peoples. In none of the cases, to my knowledge, has such a constitutional right been established in the particular circumstances, but it really did turn on the particular circumstances. Moreover, in practical terms, the issue appears to have been addressed through treaties between the Canadian government and particular First Nations. However, the Canadian Supreme Court does seem to have contemplated the possibility that powers of self-government are protected by Section 35. The main qualification the court has imposed is that any such right must be an element of a practice, custom or tradition integral to the distinctive culture of the Aboriginal group claiming the right. And so in conclusion, well, what conclusions can be drawn from all of this? What would be the effect in Australian law of the constitutional recognition of Australia's First Peoples? It's of course difficult to be certain, but it does seem that, at the least, the proposed amendment would provide a premise upon which something similar to these American and Canadian doctrines could potentially be built. The existence of a fiduciary duty would probably depend, as the Australian cases have indicated, on a properly pleaded specific set of circumstances in which a fiduciary relationship would arise, having regard to the ordinary principles of Australian law on this topic. But beyond that, and noting that the way in which the Canadian jurisprudence has come to depend on the recognition of the prior and existing rights of Aboriginal peoples in Section 35 of the Constitution Act, the recognition of the prior and continuing status of Australia's First Peoples may be expected to have significant consequences in Australian law. This is because the recognition of the First Peoples of Australia is to recognise not only their prior occupation and possession of the land, but also their original status as independent, self-governing communities. And yet, as I said at the outset, this all depends on the proposition that the recognition of Australia's First Peoples would establish a constitutional premise from which implications can be drawn that extend beyond the substantive clauses of the proposed Section 129. However, it could just as cogently be argued to the contrary that clauses 1, 2 and 3 exhaust the implications to be derived from the recognition of First Peoples. It's very difficult to be exactly sure how the opening words of Section 129 would be interpreted. The nearest analogy, I would submit, is to be found in the existing preamble to the Constitution, where, as I mentioned at the outset, the agreement of the people of the Australian colonies is recalled, their agreement to unite in a federal commonwealth. And we know that the High Court has relied on the preamble to support the proposition that ultimate sovereignty is vested in the Australian people. So, all of this might seem very abstract and very theoretical and speculative, and indeed it is. But as Sir Owen Dixon once observed, theories about the ultimate grounds and fundamental assumptions of the legal system are capable of generating rules of law when they are adopted by a system of law as part of its principles. And certainly the Section 129 proposal would be to refer to Australia's Indigenous peoples as the First Peoples of Australia, very much in the sense that I think Sir Owen Dixon was referring to. Thank you very much.
Thank you very much, Professor, for that fascinating exposition. I have a question for you. What are matters relating to Indigenous and Torres Strait Islander people, and how might the High Court's acceptance of a fiduciary duty owed by the Crown to those people affect the interpretation of that phrase?
Expressed in exactly those terms, it's not a question I've turned my mind to. But it's similar to I suppose, the implicit point that I've been making, is that a lot of the debate at the moment is about what would it mean for Indigenous people to have, or the voice, I should say, to have the right to make a representation, noting that all of this backlog of case law and reasoning recognises needs to consult and accommodate. would all of that have a shaping of what it means to have a right to represent and whether there'd be implications from that? And I think your question is a similar question around what implications would it have for what is a matter that's relevant to the voice. It's a very good question because one of the other questions that's, I suppose, in the back of my mind, which I think we're not even thinking about, and maybe for good reason, but let me put the question, is, as Stuart actually pointed out, most constitutional referendums are about expansions of Commonwealth legislative power. But we don't feel like this is a case of that, because we think of Clause 3 in the proposal as being giving Parliament the power to effectively control what the voice might do. So it's seen as a limiting factor. But the question is, it is also giving the Commonwealth legislative power. How far does that power extend? Now, on its terms, it's a power to legislate with respect to matters relating to the voice as an institution. So plainly it deals with the institution as such. But is it also a matter relating to that institution as to, say, the subject matter of its representations? Now, I'm not suggesting that the High Court would say this, but the question I've been pondering is, would this give the Commonwealth Parliament the power to legislate with respect to the subject matter of a representation? Or probably more specifically, not the subject matter of it, but the actual representation? Somewhat analogously to the way in which the High Court's interpreted the external affairs power to be a power to legislate so as to implement an obligation under an international treaty. Now, I'm not suggesting that I think it does necessarily follow, but I do think it's something we need to consider whether that implication does arise. Because it would seem to me that the subject matter or content of a representation could be much wider in content or subject matter than could be legislated under the races power, for example, simply because of the scope. Now, that might get close to your question. Maybe it was what you meant, but anyway, that's my best shot at it.
Thank you. We've got time for one question from the floor. Gentleman at the front.
Thank you very much, Michael Copeman. Isn't a key problem of everything you said that there are no longer really First Peoples in Australia? There are hundreds of thousands of Australians who have some Indigenous blood, some as little as Senator Elizabeth Warren in the United States. And we cannot negotiate with a group of people who are actually mostly us as well, as if they are some foreign nation.
So that's a question that's asking me to move into territory like some of the questions that were directed at Scott. And I'd like to an extent, take Scott's approach and allow that question to go through to the keeper a little. But look, it's a really good question. I suppose my point is I'm not sure how to answer that, because what I can say is that what I'm saying is that this is a constitutional recognition of First Peoples. So the High Court and the courts have to give effect to that. So it's acknowledging that they are peoples and that they do exist as such constitutionally. So any objection along the lines that you're raising would, in a sense, even if factually supported, and I make no comment on that, I mean, there's good reason to think it is factually supported to an extent, would be trumped by the Constitution itself. I think this is why, a lot of attention's been placed on the tripartite test in the Mabo case, because we have to have some sort of definition of what makes for an Indigenous community or an Indigenous people. And so that's going to be a very important dimension of the practical meaning of section 129.
Thank you very much, Professor. Please join me in thanking Professor Nicholas Aroney.